Hello, and welcome to today's webinar on how to streamline your legal holds and address challenges and enhance efficiency. My name is Brendan Locke, Marketing Campaign Manager at Reveal, and today I will be your event producer. Before I turn this webinar over to our esteemed panelists, there are a few housekeeping items I wanted to share with you. A common question we always get asked in our webinars is, will this webinar be recorded and will this webinar be available on demand? And the answer is yes to both. We will share the recording of this webinar to everyone the day after the live webinar, and it will also be available on Reveal's website. If you have any questions during the webinar, please submit your questions in the Q&A section on the right side of your screen. We will gather all the questions submitted and share them with our presenters, and we will follow up with you shortly after the webinar is complete. Lastly, this webinar is a thought leadership-based webinar. But if you would like to learn more about Reveal Legal Hold or any of Reveal's products, I welcome you to request a demo by clicking the button on the upper right-hand side of your screen. And with that, it is my great pleasure to turn this webinar over to our moderator, Tony.
Thank you for joining us, registered attendees and esteemed panelists, for today's insightful discussion on, again, how to streamline your legal holds, addressing challenges and enhancing efficiency. Navigating through the complexity of legal holds presents a myriad of challenges for organizations across various sectors, from identifying the relevant information to ensuring compliance with legal and regulatory changes. The journey of managing legal hold is fraught with obstacles. So today, we're going to delve into these challenges, explore best practices for overcoming them, and the role cutting-edge technology plays to streamlining the legal hold process. So now, before we deep dive into our discussion, allow me to introduce myself. I am Tony Milliken, a Managing Director of Customer Success here at Reveal, and I'm your moderator for today's session. With extensive experience in managing governance, litigation support, and e-discovery practices with my tenure in-house corporation, I'm thrilled to guide us through this exploration of legal hold management. But of course, our conversation wouldn't be complete without the insights and expertise of our esteemed panelists, which each brings a unique perspective of wealth and knowledge to our discussion. So without further ado, I would like to invite each of our panelists to introduce themselves briefly, sharing their name, affiliation, and perhaps a glimpse into their experience. So let's start with Aaron Bath, and then we'll follow up with Allison Mears and then Amanda Strauss. Panelists, please take a moment to introduce yourselves.
Got it. Hi, everyone. I'm Aaron Bath. I'm based in Dallas, Texas. I'm the National Director of Litigation Management and Legal Operations for Balfour Beatty. That's a large global infrastructure company based in London. And in addition, I'm an adjunct professor of legal technology at Southern Methodist University.
Thank you. And can we go ahead, Allison?
Hi, everybody. I'm Allison Mears. I'm a paralegal over at Arcosa Incorporated. We are also in the construction and manufacturing space, and I assist with managing a lot of our litigation support and e-discovery lines of services. And I'm here to give some perspective on the workflow and operations side of legal hold and how that can impact your team.
Thank you, Allison. And finally, Amanda.
Hi, my name is Amanda Strauss. I am Corporate Legal Counsel for FL Smith. We are a global equipment supplier for the mining industry. I sit in our Allentown, Pennsylvania office, and our parent company is based in Denmark. As part of my role, I manage our e-discovery projects, and previously more than got my feet wet doing e-discovery in private practice for 8 years in New York City. I'm really looking forward to being here today.
Thank you, panelists. It's evident that each of you bring a wealth of experience and expertise to our discussion. So let's go ahead into our first question. Considering your diverse backgrounds and roles within your respective organizations, could you share with us your experience with legal holds and why they're particularly important to your organization? I'd like to start with Amanda, if you can give us your perspective.
Sure, thanks, Tony. So I use legal holds at my company for two main buckets of work, right? So the one is active or pending disputes. So anytime we get a complaint, we get a third-party subpoena, or we even just have a suspicion that there might be a dispute that's going to arise, we make sure that we immediately put the relevant custodians on hold. Obviously, that's really important because we want to make sure we're preserving any documents that may be relevant, whether it's for our defense, in order to advocate for our company, and also to make sure that we aren't at risk of any spoliation allegations, which I know we'll get into a little later as well. As far as the second bucket would be internal investigations, right? So we may have an instance where we have a whistleblower or suspicion that somebody is sending company IP outside of the company. Maybe they're trying to go to a competitor. And so we need to make sure that we're able to preserve all of their data and in order to build our case and know what's happening and protect the company and its interests. In those instances, what's super important is that we can put people on hold without them knowing, right? So we can follow through on our investigation without really waving the flag. And so in that instance, we implement what we call silent or stealth hold. And that's enables us to put their documents on a legal hold on the technical, on the IT side, without telling them that we're doing so, and that they have no knowledge and it doesn't interfere with their day-to-day work.
Great points. Allison, how about you? Can you give us your perspective on this, on how the importance and your experience?
Absolutely. Kind of piggybacking on Amanda. Yeah, I'm receiving notice of the need to issue a legal hold in my department for anticipated litigation, investigations, potential claims. If there's any regulatory discussions or possibly sometimes M&A that might impact our businesses or our departments. It's extremely important that these are done timely for us for several important reasons. One is to help us better understand the landscape of the matter or the project that's at hand, helping us to identify key custodians and non-custodial data sources through those interviews that will take place once the hold has been issued, or possibly questionnaires that might accompany it. And that sending this notice to our custodians or any non-custodial data sources, putting preservations in place, just further assists in ensuring compliance and that we are litigation ready should the time come. Also, taking prompt action will help us to ensure that our data governance and our retention policies are not going to adversely impact the scope of this project. It's so important to keep in mind, whether it's your clients or yourselves from the in-house perspective, that that's not going to be impacting you down the road, and that you're keeping an eye on that wider horizon when it comes to the preservation of key information.
Thank you, Allison. And Aaron, as I recall from our previous discussions, from your point of view, it's about looking at the legal versus practical importance.
Yeah. There's a great quote that I like to share with my students. It's very dramatic. It's from the United Medical Company versus U.S. case. Federal court says, aside perhaps from perjury, no act serves to threaten the integrity of the judicial process more than spoliation of evidence, right? Great quote. But the takeaway from that is I remember starting my career as a young hot seater at trials. I quickly learned that, yes, facts matter, but the people that tend to win cases are the ones that have the best documents, the best data, have them the most organized, and know how to deploy them with efficiency, right? So you can't lose track of, yes, there are definitely legal ramifications for not having good legal hold and preservation programs in place. But from a practical standpoint, as a practitioner and as a member of a trial team, the data is your evidence and the evidence is your case. And if you don't have it preserved and you can't access it, you've lost your ability to effectively argue your case or defend your company.
Sorry, got a little happy with my mute button there. So that kind of leads into my next question, Aaron. You've tipped the iceberg really about the importance of failing to meet those legal hold practices. Can you talk a little bit more about failing to meet those practices?
Yeah, so there's a number of things that can happen that are scary for companies, right? With a lot of risk involved, and a lot of people are familiar with the term sanctions and about financial penalties that can happen if you fail to preserve or issue an effective legal hold. I think it's worth looking up if you're not familiar with it. FRCP 37E, which is the spoliation, and it shows kind of the logic chain of a judge looking at a company's actions and the steps that they took to preserve data. And again, the courts are not looking for perfection, but they're looking for reasonable steps. And those have been established through, frankly, a lot of case law. A very famous case, the Zubilake versus, I think it's UTB Warburg case, is a quintessential case that kind of lays out what companies ought to do. So the scary thing about that is there's kind of different levels of penalties that can hit you. Sanctions are certainly one of them. But if they can prove that you failed to take reasonable steps, or worse, that there was intent to deprive, right, maliciousness on a party side, those penalties get worse, including adverse actions and even the death penalty sanction, which is an outright you lost the case. And that can be catastrophic when you're talking about cases of high value.
Agreed. And Amanda, given your experience, I know you've been in-house and as outside counsel, what's your response to the question about the importance of failing to meet the legal hold practices?
Yeah, I mean, Aaron really hit the sanctions and spoliation risk on the head. And so, from a practical matter, when you're outside counsel, at least in my experience, our clients were really relying on us to get our hands around the case quickly, figure out who those custodians would be, do our interviews with the key stakeholders so we could come up with that list, and very quickly draft the litigation hold and distribute it to our counterpart at the client so they can distribute it internally to their stakeholders. And it was really on us in order to, do that quickly, efficiently, and as accurately as possible. Of course, there may be opportunities throughout the investigation where you'll need to update that. You might learn something as you're reviewing documents or continuing with interviews that somebody needs to be added, scope needs to be expanded. But in order to get that hold out quickly, you really do want to get as much information as you can from the beginning. And in-house counsel, it's really the same. You maybe have a little more insight, right? So you might know the people a little more. You might know the project that was being worked on, and you might have a better sense of the hierarchy, organizational charts, and who might need to be pulled into that litigation hold. But really getting that in place as soon as possible is the quickest way to avoid that spoliation risk. I mean, I know here at FL Smith, we have pretty strict data retention policies. And so you don't know if you're coming up on that, let's say, 1 year, 3 year mark, whatever it might be, where a former employee's mailbox might be deleted, and there's, a risk that might be gone if you miss your date. So you always want to get that in as soon as possible. And then I would just add compliance, right? So in-house, it's a little easier to be on top of people, confirm that they're complying, track their compliance, and maybe, get those collections done. But when you're working as outside counsel with a client who you don't necessarily have insight to all their stakeholders and direct connections to them, confirming that people received the legal hold, confirming that people understood the legal hold, confirming that people acknowledged the legal hold and then are complying with it can be very difficult.
Absolutely. And Allison, do you have any summarizing thoughts before I move on to my next question?
Yeah, I think Amanda and Aaron have done a great job just kind of taking a big view of a lot of these risks that we take on once we enter into this process, and just reiterating what they're saying with a failure to timely issue these out and to make sure that they are exact and properly thought out when it comes to the scope of information that needs to be held onto your key custodians, your key players, your non-custodial data sources. A lot of adverse outcomes can come from that. As Aaron and Amanda have said, imposed sanctions is definitely top of mind for people, additional penalties or even more litigation coming from that. The lack of evidence to support your claim or your defense is going to result in an increased cost to locate, process, or produce that information, or even worse, a loss of evidence is going to be an even higher increased cost to potentially retrieve or remediate that should the court deem you to do so. And also, there's a damage, right, to your credibility sometimes when these things happen to yourself, to your firm, to your organization, or possibly just a disfavor with the court, even if there are no imposed sanctions.
Yeah, I think what I'm hearing resonating, that farther to the left, right, of that EDRM, that importance around that identification and preservation really is key. So when we look at, now that we've kind of explored the importance of those legal holds, I want to transition into the next topic, which is really about the common challenges and best practices that you've implemented for overcoming. So as we're navigating through that landscape of legal hold management, it's, we understand it's essential to recognize that there are going to be those frequent pain points that organizations will encounter in their day-to-day operations. So panelists, I do want to open the floor to discuss some of the reoccurring obstacles and how do they impact the organization's ability to affect and manage those legal holds. So, I'm going to start back with Allison. So when you're prepping, when we actually prepped for this call, I know we talked about post-issuance of legal hold and the ability to understand organizational changes across your teams and your business groups. Can you elaborate a little bit on that challenge?
Yeah, absolutely. I think this is a frequent flyer along the timeline of legal hold management, the management side, post-issuance. A key thing that comes up is when there is a change in scope that might merit you revisiting the existing legal hold. How frequently are you involved in case updates or discussions with outside counsel or your IT and HR partners? Are there internal things that are going on? Are we doing database changes that could impact the life of this legal hold as it goes down? So make sure that you have these continual touch points with your key stakeholders internally and externally. If some people have along the HR and IT side, when it comes to monitoring employee change management, are employees changing roles? Are they leaving the company? Do we have new hires? Are they moving to another department? These are a lot of things that can kind of just fly under the radar and you don't even know about it until 6-8 months down the road, and now you have to go back and you need to either issue a notice or you need to go ahead and retrieve information that might be located somewhere else now because it's been moved to a new person's share drive. Also, just having those connections with HR, IT, and anyone else, knowing their system, seeing if you can piggyback on what they have available just to help both departments run together effectively. That's going to really, really make a huge difference along the timeline of managing these holds.
Sure. And Aaron, I know it's not solely about, the role changes of employees. I think we need to address that big elephant in the room that all of us have faced, which is the ever expanding array of all of the communication and productivity platforms that are being utilized by organizations. So can you talk a little bit about that challenge and how you're working to overcome that obstacle?
Yeah, absolutely. And just a quick note on custodian changes and things like that. We also want to keep in mind that there's custodial data, there's non-custodial data that we got to look at too. So we're not just looking at custodians that have left, but also people that might be your contact or your stakeholder for offsite storage or structured data reports that are often a part of holds. But as communication landscapes change and people are using more productivity tools, it gets really challenging, right? Because like what I found is there's always a divide between IT and legal and this like weird ownership of job duties of, I don't want to let you into my club and, I don't want to give you keys to the systems, right? And so there's always this kind of battle that goes on when you start a new position at a company. And that's a problem because a lot of these tools that IT is using to manage our data, most of us are Microsoft shops, right? So O365 purview compliance. It has a lot of features that are around policy deployment and management compliance, but of course it also has discovery tools. The gap is that IT doesn't know about discovery, right? And legal doesn't know about the technical tools of O365 purview and compliance. So there really has to be kind of a process of cross-pollination and training and education to make sure that one, IT knows what's important, knows how to get us what we need and how to help us support our legal processes. The big problem I'm finding, of course, post-COVID is, communication platforms like Teams or Asana or anything that has like an element of chat or short messaging. And there's been some really powerful case law in the past couple of years that have illuminated the giant problem here. There's, recently the Google antitrust case where using Google Chat, they had a 1-day retention policy on Google Chat, right? And of course, the courts found you're a sophisticated litigant. It is actually your software. You should know better that if you're under legal hold, that retention policy needs to be longer than a day. There's other cases like recently in 2021, the FTC Nolan case, where it was found employees were moving to an ephemeral messaging system. I think it was Signal, to move communications offline so they could have discussions that they thought weren't discoverable, and of course that ended poorly. So there's all of these kind of issues that we have to deal with, and a lot of that means we have to ask for outside help. I know some of you are more technical than I am, but I don't know how to go in and collect the data from Teams in a way that's useful, that I can run my AI models against it. Nor does my IT team, and that's not an embarrassing thing to admit. It's a new need that we have that's developed recently, and so we got to be able to raise our hand and ask for help. And there's a ton of great LSPs, service providers out there that do just this. So bringing them on board helps with that issue. And I guess lastly, talking about overcoming that problem. It's just what I do, and I saw Amanda's head shaking too, and probably Allison also. When I start a new job, the first thing I do is I go make friends with people in IT and HR. I want them to know me and understand my role, that I'm not a threat to their job, that I'm not trying to take anything over, that I'm working with them as a collaborative partner. And a big thing that I found as help is when you build out your playbooks for a company, bringing in the executives of the different department as part of that process, asking them how they can best partner on these different processes that we do. And that way, when the mandate comes down of this is what you have to do when there's a legal hold, they have buy-in because they were part of developing that solution.
Yeah, those are good points. And, when you talk about post-COVID and even just the communication platforms, what also resonates with me, which we didn't touch on a lot, but, I'm thinking about that more. It's even those what I would call field workers, those people, the mobile device, right? Yes. All of the other components involved, and mobile management and having that relationship with IT, I'm sure, is pivotal as well. Yeah. Absolutely. Okay. So Allison, what about the other data sources being introduced in your organization? It's not just about those short messaging and collaboration productivity platforms, but technologies are coming and going, right, to just manage the business. Can you talk about a little bit about that challenge and how you're overcoming, whether it's a new system or a decom of a system?
Yeah, I experience seeing new systems coming into the organization pretty frequently. And the first discussion I'm going to be having is, all right, retention policy implementation. Can we implement some sort of automated monitoring to help us better abide by our retention schedules, and just have an overall better management over the lifetime of this new system? Who is going to be using it? What kind of data is it going to be storing? What type of information? And can I get it out? What form is it going to be coming out in? Because down the line, once we get to the middle and the right side of the EDRM, that's going to be very, very pivotal. Also, it's kind of the same thing when it comes to systems decommissioning. A lot of people are changing over to new systems with acquisitions. We're bringing a lot of new systems on that already have workflows in place. This is how we've always done it. So getting in there and having these discussions ahead of time with these key players, the owners of these systems, and just like Aaron keeps saying, also having those interpersonal connections, introducing yourself, being familiar, and knowing that you are a source of information that can be helpful to them, and likewise that they can be helpful to you. I think that when it comes to new systems, decommissioning systems, and also keeping an eye on, internally for me, acquisitions and divestitures, technology management, that's where most of my focus is going to be. And then how are you overcoming it when you're having these discussions? Are you partnering with IT to develop some sort of a data source map or do you have one? If and how mature is it? They can really be game changers within your organization if you do not have one. I have developed the perspective of some is better than none, whether it's a list of data sources you know are there through interpersonal interactions with key stakeholders. Find out who administrates them and can we pull information out? Like, just having a comprehensive list like that is very, very helpful, whether it's that or you have a data management software that you're using across the organization. Some is going to be better than none.
Thank you. And I want to touch a little bit again on that. Erin, I remember we spoke briefly, tagging on to that conversation, the onboarding of new technology, and the business is excited to bring something on new, and there's a lot of project management associated to that. But there's also there's that cost for discovery, right? The association of discovering, because all data is discoverable. How do you manage the challenge of ensuring that there's that budgetary cost associated to actually bringing that new system online?
Yeah, no, that's a good point. And this is going to be different business to business. I work in an infrastructure, large construction global company that we build things, whether it be vertical high rises or bridges or highway systems. We build these big projects and those projects have a budget. And so it's important kind of at the front end of a project to meet and confer and talk about the technology that's going to be used. And there's generally a discussion with legal in terms of, from a legal perspective, should there be claims or things we have to mitigate? What are we going to use and what does that budget look like? And new technologies, it's kind of interesting in our world. We have a lot of cool technology that we use. People have heard me talk about, our business uses those Boston Dynamic robot dogs that are very scary and make you feel like you're in a episode of Black Mirror, but they're equipped with LiDAR sensors and cameras, and they will literally run up and down buildings measuring the progress of its development over time. And so you think about from a challenging perspective of like, wow, how do I preserve a robot dog? how do I look at what's in its brain? Like, what does this look like? And so like a really good practice one is to explore that up front, what consulting fees to figure that out might cost. For us, we often bill that back to the project, right? So we kind of have a pocket to assign it to. But then you also go through the proactive steps of like, how do we do it? Do we need to do some simulations and some practices to see what that data looks like? Because preserving it's not enough if you can't do anything with it, right? You also have to be able to leverage it in court or in discovery. So yeah, it's a process that's got to be negotiated and brought to the attention of the right cross-functional teams.
Yeah, I'm definitely hearing it's better to have that conversation on the front end rather than making it reactive when you need to discover.
Yeah.
Okay, I think another challenge that we hit on during our conversation, Amanda, you also work at a global organization. How do data privacy concerns impact the management of your legal holds, and how are you overcoming those challenges?
Thanks, Tony. Yeah, this is a huge consideration if you are working in a global organization or an organization that has offices in certain US states even that are beginning to develop their own data privacy laws. So we, like I mentioned earlier, like Tony mentioned, we are global. Our parent company is in Denmark, and we have offices and employees all over the world. So we are constantly considering GDPR compliance when we are engaging in e-discovery and making sure that we have the appropriate compliance and standards in place so that we are not breaching any of our employees' rights. We have a specific GDPR data privacy expert who is based in Germany, and so he's one of our attorneys as well, and so we will go to him with our GDPR specific questions so that we can consult him and make sure that the strategies we are looking to engage in are compliant and do that analysis before we proceed, right? And one way we make sure that we are compliant is we will have servers in different places to host data so that it's more appropriate geographically and local to where those custodians are. So we are not, technologically transmitting their data outside of a GDPR permissible location.
Thank you. I that was one thing I know resonated with me. Never did I think I'd be getting into privacy law when I first started my career in e-discovery, and it's really front and center now. We're all thinking about it. We're all talking about it. Amanda, you also touched on the challenge of the discrete, or sometimes referred to as that stealth custodian. You mentioned it previously, and I want to discuss some ways of how you're managing the discrete custodian.
So previously, when we would be submitting stealth legal holds, there would be essentially just an email that would go out to our IT team and say, can you please put Amanda Strauss on hold? And that would kind of be the end of it, because we wouldn't be sending them hold notice. So it would just be IT flipping the switch in Purview. Now, as we've been using Reveal Legal Hold, we have a really great feature where we can input the case data as we would for any legal hold, add our custodians from Active Directory, and then instead of sending out a hold, you just flip the switch to say, well, this is a stealth hold, send it, and they won't ever be notified. And this is a huge improvement from even before, right? Even earlier, what we used to do when we would have to do more hard drive collections and we would want to mirror somebody's entire laptop, this is where everything was really cloud-based. We would essentially, in the background, run a program on a stealth custodian's desktop in order to mirror it and bring it over, but it would slow their programs down and make their computer run really slow. And they would end up calling IT and say, what's going on with my computer? It's not working. And, legal would know what was happening, but we couldn't tell them what was happening. We didn't really have any other option. So, technology has really come far for us with these stealth custodians, and it may not seem as significant, but it really makes a big difference when you're working on an internal investigation.
Great points. And, there's a lot of discussion about the human conditioning, and overcoming one of the biggest challenges I think we've all faced with legal hold programs. That's really the compliance from both your custodians and Aaron touched on those non-custodian data sources, those data stewards. Aaron, share with us some about the internal marketing campaign aspect. Your marketing and your campaigning to combat that human element, that human touch.
Yeah, first, I just want to +1 Amanda on the awkwardness of having a silent custodian reach out to you about the legal hold they're not supposed to know about. It happened to me. It's terrible. But speaking of awkward, it's also awkward for me in that the majority, it was new to me coming into a construction company because I have a tech company background. I was surprised to learn a lot of construction lawyers are not litigators, right? A lot of them are very transactional and work a lot with contracts and other facets of the law. And so, there's not always guaranteed that they know about preservation and legal holds. And so what happens is their boots on the ground divisionally to our business units. That's who the construction teams know. They don't know me, who's working on litigation and investigations in the background, working with outside counsel. So when I would send out a legal hold notice, there's like an immediate chaos reaction of like, stranger danger, who is this guy that's reaching out? I don't know him. Is this legitimate? Is this a phishing exercise? Like, am I in trouble? Right. So it would escalate. And it was a learning experience for me to understand you have to socialize and educate these preservation and legal hold programs to the company at large. And so we've done things like partner with our marketing group, not to just put things on a website because no one's going to go looking up what to do on a legal hold. That's not fun. But if you push out marketing materials with, your face and your title and what your job entails and what is a legal hold, and you're not in trouble. We don't care about your personal documents. We're looking to preserve what's responsive to the claims. And you might get emails from this guy and it's okay. And, acknowledgement is important. Those kind of like messages that go out to the team are really helpful. And also every company undergoes, a couple times a year, we get those emails. You have to do your compliance training, learning about harassment, learning about gifts and kickbacks, all those different topics. Why not make preservation and legal hold a part of that, right? That can be covered very quickly. And it's something that can be, done at meetings, safety meetings, things like that, folded in as kind of part of understanding the business in a holistic sense.
Yeah, key to onboarding new employees for sure. Allison, you talked about the power of building that trust through communication as well. Give me some of your thoughts there.
Yeah, I am a firm believer in not taking for granted the power of your soft skills. These can just be essential for effective personal, professional, and personal interactions. It's funny, this week I shared a LinkedIn post from Rich Robinson over at Toyota, where he spends a lot of time just really breaking down the importance of this aspect within the legal technology industry. And he goes through the five essential skills of leadership, collaboration, adaptability, ingenuity, and emotional intelligence. And emotional intelligence just does nothing but builds trust, right? It can facilitate understanding, it can foster that trust and strengthen your relationship with the team and the stakeholders that you're working with. And active listening, that can also allow us to discern roots of issues as opposed to what might be presented at face value, to really analyze what you're seeing and taking in those discussions. And being able to code switch is one of the most important skills I have learned just in the trenches in my current role, to be able to change the context and the verbiage of the type of speak that you're using to cater to the type of audience that you're speaking with. That makes a huge difference in the custodial interviews when I am working with industry laborers who, as Aaron mentioned, see that notice come through and like, legal hold, what is this? I didn't do anything wrong. And they're immediately on high alert. They're not in an executive state. They're nervous. And to be able to immediately come in, connect with them, being very mindful of their perspective, and to be a helping hand through this process. Right in the end, for us in our role, we're here to truly understand what happened and how our attorneys or outside counsel defend that to the best of our ability. And so along the lines of mindfulness, when you are interacting with them, kind of think about that impact. It's maybe don't just send an email saying, hi, so-and-so, I need to meet with you to go over, these requests for protections that came through, or ask about these data sources that you might have. Let's sit down and talk. And sometimes these are hourly laborers. If they're not working, they're not producing. And so to be able to just halt their day and meet your tight timeline can be really, really difficult. So take that into consideration when you are talking with whoever you might be dealing with. Meet on their terms, whether it's a group setting. If it's helpful to have all of these stakeholders in one room, having these discussions, you never know what will come up that someone else goes, oh, really? I didn't know that happened. Well, hey, that makes me think of this. And then before you know it, all kinds of information is coming up that's going to really help all parties navigate through the scope of this litigation or project or whatever it might be. Or if you need to keep it fairly discreet, going back to those discreet custodians, meet one-on-one and find it in a way and in a form that is comfortable for them. And then the communication of that information, communicate with their preferred form. Find out, are they someone who likes to pick up the phone and call? Yeah, that's really hard for us who are kind of a CYA type of personality. But follow up with that call with a summary of what you talked about and what will take place. I'm a big fan of phone calls if it's not face-to-face, but I always summarize our discussions, or email or messaging platform. If they're using Slack or Teams or something like that, maybe that's how they want to communicate. So just take into some of those considerations of mindfulness, speaking to your audience, active listening, and just the emotional intelligence of it all.
Yeah, you talk about the laborer, and that reminds me, some of my surprisingly most challenging but favorite times really was partnering with my multilingual peers, right? To help with that. It helped with the openness and trust of laborers when you were talking about that potential of being notified that you had some sort of legal hold requirement.
Yes. Also, making sure that if you do have multilingual individuals on hold, create one in their language. Put the effort into that. That makes a world of difference.
Absolutely. Now, Amanda, you have an opportunity of gaining some compliance from the relationships that you've built. You're not just working litigation and investigation. Your scope in-house is a lot more broad. So I'd like to see how you take advantage of your role and the relationships that you've built.
Thanks. Absolutely. So as legal counsel at FLS, I'm not just managing our e-discovery. That's just a small portion of what I do every day. A lot of what I do every day is contract reviews. So whether it's sales or procurement, I'm constantly working with the business teams to help them get a deal. And so I am always, I know not everybody, but a lot of people who may be on a legal hold. And if I don't know them, other members of the legal team knows them. Other members of the legal team know who worked on that project. And so it really helps to build that relationship from the beginning, right? They know me, they trust me, or they trust my boss, and we can create that rapport that we've already been establishing through the review of the contract, getting them through to the project time. And then I might not always know the people who've been working on the project, right? Our contracts transition from sales to project management, but there's usually a blend between where the issue is, right? So we always usually have some salespeople, some project people involved, and I get them all, like Allison was saying, assuming it's not a sensitive issue, in one room or on one Teams call, so that we can all be together talking about the issue, because inevitably somebody remembers one thing, somebody remembers something else, and we put those things together and the story all makes sense. So it's really important to establish that rapport for me from the beginning, so that when I need them down the road, they trust me and they're happy to help. It's also great because you know that these salespeople and these project managers are passionate about their projects and they want to help you, right? If something goes wrong, they take ownership of that. And so they want you to know the story from their perspective, so that we can best defend the company or represent the company in its interests, whichever side we may be on. So that personal touch and making those relationships really counts.
Yeah, that's good, because I know, trying to combat not the interruption of the day-to-day, but the fact that you're able to lean on that relationship and that they care so much on defending those alleged claims, that definitely resonates. So, I don't want to lose sight of some other key areas of focus when we talk about some of the challenges that we need to be considering here. And Aaron, you made some really good talking points with us on some areas that we don't want to lose sight of when we're adhering to best practices. One is let's talk about the custodian acknowledgement before we head into our last topic.
Yeah, for sure. And even when it comes to acknowledgement and the legal hold notice itself, it's really important for people to fully understand what's required, whether it be through the rules, whether it be statutorily or kind of established in recent case law. Because I see a lot of people get very close, but they're missing a key element that makes it effective, right? So a good example is the legal hold acknowledgement. Acknowledgement itself is not enough. There's 4 elements that you have to satisfy, right, for it to be valid. The language has to say that they received, read, understand, and intend to comply. And I often see that intend to comply left off of the acknowledgement language, and that won't hold up in a court challenge. Similarly, the legal hold notices need to be clear and instructive. They're not meant to be a legal document that covers everything. Biggest mistake I always see in legal hold notices or ESI protocols, frankly, is trying to throw in everything under the kitchen sink and not making it bespoke to your specific company, your specific data endpoints, your specific needs for the case. You don't want to cover everything because it'll confuse the recipient. You want it to be clear, detailed, and a resource for the recipient to know what to do, to know what this is about, to know who to contact. And it needs to deal with the endpoints that they actually use, not every possible endpoint that's known to man. And so I think it's important to pause, and do a little research and make sure you're up to speed before you send a written notice or develop your template, or before you draft the template of your acknowledgement language to make sure that you comply with the law and expectations.
And what about, we've talked about the notice itself. We talked about the acknowledgements. You know, there's a lot of conversations about those periodic reminders or awarenesses. If you can talk about best practice there as well.
And this is a good time. There's a great resource. I think it's a few years old now, but the Sedona Conference, the commentary on legal holds, 21 maybe. I don't know if it's 19 or 21. It's like time has flown by since the pandemic, but it has, I want to say guidelines like 8 through 12 talk about a lot of topics that get overlooked. And that is, you want to check in and monitor and send reminder notices about legal holds at certain intervals to keep it fresh in the minds of the people. You know, oftentimes we have custodians that are on multiple holds, right? Or maybe they get the one notice and that's the only communication they ever get. And is that enough to keep them remembering not to delete, not to preserve, not to expedite their deletion, retention policies? So you've got to keep it active on their minds and fresh in their minds. There's also regular monitoring of the compliance. One thing we do is we set automatic reports that come to me or my team that show the status of acknowledgements for the various cases under our control. And so we can see, great, I'm at 100%. I can kind of check this off for now, or man, I'm missing 2 people that I know are still active employees. I need to follow up with them and get this to 100%. So that follow up and getting to 100, keeping it fresh in the minds, and then also just remembering to release the hold when you're satisfactorily past, you know, any threat. You know, after the appeals process or after settlement, after you have some time pass and you consult with your attorneys, is it now safe to release this hold? Is our obligation fulfilled, right? And turning it off so you can have good data hygiene and good clarity of who's on what hold and what's in place at any given time for reporting.
Yeah, and I think, Amanda, too, you know, I remember you touching about the power of leveraging the questionnaire to understand the scope change, right? You may think you know the relevant custodians or the relevant data points. Can you speak a little bit about that as well?
I'd love to. So that questionnaire is really key. When you send out your legal hold and you ask them, okay, where might you have data? Is it electronic? Is it hard copies? Is it on thumb drives? Is it on your laptop? What cloud sources? And is there anyone else who you think might have relevant information, right? And so it creates your web and then really helps you create your data map so that you can track and find all that data and put those people and those sources, custodial or not, on hold. And yeah, I mean, that really segues with the technology aspect, if I can expand on that a little more. So this is previously, you know, something that we did have in our last software, but it wasn't the best functionality. So previously our software would essentially, we could send out legal hold notices from it. We could send out a questionnaire, but that's kind of where it stopped. And we didn't really have a way of tracking custodians and determining if they were multiple holds. It had no connectivity to IT to put them on hold. We had to have a separate spreadsheet to track, you know, what holds people were on to make sure we released them from one. You know, if they were on another hold, we weren't releasing them from those as well. And using the new Reveal Hold software, I just have to give it a plug here. I know, you know, I wasn't asked to, but I have to, because it's been really, really a huge improvement for us, where we can now have all our custodians from Active Directory, all our employees from Active Directory in our system, add them as custodians to relevant matter, send out those holds. They immediately get the questionnaire when they go and click on the link. We can review those answers, expand on our holds as needed, and then we can, if something scope changes, we can change it in Reveal Hold. And if we have, let's say I'm on multiple holds, but one of those matters closes, my hold in the back end won't be lifted because I'm still on hold on 2 other matters. So that fulsome connectivity, fulsome platform is a huge improvement, and we're really excited to be using it now. You know, when I was in private practice, obviously that was some time ago, but the platform there was much more, you know, rudimentary. We had a database internally where we could draft legal holds and send them out to our individuals and track compliance in there. but I don't believe it had any link to IT. And when it came to external holds, there was no connectivity with outside clients. It was just literally a Word document that we PDF'd and emailed. So I'm really excited to see how, this platform, for us in-house, we're already seeing it. And I'm excited to see from, as an outsider, how, outside counsel, private practitioners can utilize it as well.
Thank you, Amanda. And I do appreciate you really stepping into the last point I wanted to talk about. I do think it's crucial to set aside, time to talk about how technology is becoming increasingly important in making the legal hold programs more efficient and compliant. And so even though there are many other things that we could be digging into today, there's a lot more discussion just around legal hold process. I do want to shift our focus to this crucial aspect and uncover the role technology is playing to improve the efficiency of compliance of legal hold programs. So Amanda, thank you for your content. Allison, love to hear from you about how technology is improving your efficiencies.
Yeah, I've been, I guess it is fortunate because there's always a learning leap between one platform to another. I've been through in 3 platforms over the last 7 years, and I'm constantly encouraged with each new step by seeing a lot of really exciting new features that are going to drive more efficiencies and help me to do my day-to-day job a lot better. That does not rely on exporting report spreadsheets and configuring and having to have these weekly reports that I'm spending 2-3 hours, if I'm lucky, trying to get them together for a quick 15-minute meeting. There's just not a lot of return on that for me in the past. And so I have really liked a lot of the new technologies that are coming out. Again, I also have to talk about how Reveal has helped changed my approach to things with some of these new tools. And I know a lot of others may have them, but Reveal has been where we called home. I had not had an ability to kind of have a workflow approval. We are a small team, and so it's usually I receive the hold, I issue the hold, I draft the hold, I issue the hold, I maintain the hold. And I feel like that's me being a little too close to the entire process. I really needed some accountability there. If there's anyone to kind of take a look at my work, we can avoid user error with manual inputs by implementing an approval process. And so I'm about to turn that back on. We did some workflow switching lately, and so I want to make sure that everything's running smoothly there. But I cannot wait to turn on that approval workflow again. I think that's going to really help avoid any confusion in the future. And then employee change monitoring, I've talked about it before. It's very, very important. I think it may not always yield a result to you, right? There may not be a shift in a hold. But the one time there is, you're going to be really happy that you had the ability to see that someone's position changed or someone has left and a new person has taken that position and is currently involved in active information for whatever the matter or the project is that you're dealing with. So I have not had kind of a robust way to do that. It's been reports through our HR system. And so I'm excited to be able to leverage technology like that moving forward. And then the ability to just so quickly issue and release holds, just the whole management of that. And not just the hold itself, the project, the notice, all the way down to the custodian. I can individually pick who I want to receive a notice, to not receive a notice, who I want to be discreet, who I need to reissue on a one-by-one level. I've not been able to do that on a custodian level. It's always been at a project level. So I'm kind of debating, do I want to resend this entire notice out to everybody just for this slight tweak that we've done, or to remind someone? Then I'd have to remind everybody, even though those who have already accepted the hold. So I'm thinking about end user impact there. So I'm diminishing that with a little more configurability in the way that I'm managing these. And I think I had one more. Oh, just data integrity by being able to release these holds on a matter by matter basis. Before they were on custodial basis. So we had to do, again, pulling more reports to make sure X custodian wasn't a part of any other hold. So just, again, streamlining more efficiencies that have come through that. I feel like we're entering into a blooming era right now for our legal hold practices. And I'm on board for it. I'm all in. I'm excited.
Definitely sounds with as teams continue to grow smaller, technology is really helping you do more with less resources for sure.
Yeah, absolutely. I'm living in that right now.
Yeah. Aaron, I want to leave with your thoughts here on technology.
Yeah, and I'll be quick. I know we're short on time. We're kind of like Allison. We're about to launch our third legal hold tool in 7 years. Our first one was terrible. Our second one was pretty good. And of course, we saved the best for last, moving into Reveal Hold. We have been a Reveal e-discovery client for a long time, so I'm excited about the integrations there. We spent a lot of time and resources investing in building very bespoke AI models to our business and our industry. And so being able to have cross functionality between holds through review, through production is going to be incredible. I'm looking forward to having actual data connectors and being able to collect from within the platform. Of course, the report automation that Allison mentioned is going to be key. So yeah, we're super excited about the move, and we launch on Monday. So
thank you, panelists. I appreciate all of your time, and now I'm going to send it over to Brendan.
Yes, thank you, Tony, Amanda, Allison, and Aaron. I really enjoyed listening in the conversation today, and I'm sure our audience did too. And thank you, everyone, for joining us and taking time out of your busy day to listen to our webinar. As we wrap up, I just want to remind you all, if you have any questions, please put them in the Q&A section, and we will be following up with you shortly. And lastly, if you would like to learn more about Reveal Legal Hold or any of Reveal products, again, I welcome you to click the demo request at the top of your screen. And with that, thank you, everyone, for your time today, and thank you, our panelists, for your great presentation, and have a great rest of your day.